I had been driving for 3 hours when I pulled into the Cedar Grove rest stop just past the state line. It was late. Not midnight late, just that heavy blue-hour stretch when the sky is almost dark but not fully committed. The kind of hour where headlights feel brighter than they should. The asphalt still held warmth from the day. Trucks idled in the distance. A vending machine hummed inside the building like it had for the last 20 years. I was tired. Not physically, I'd slept well, but mentally tired, in the way that comes from presiding over a week of arraignments, motions, and probation violations. My calendar had been packed, my rulings measured, my voice controlled. Most people don't recognize judges outside of a courtroom. We're less visible than prosecutors or politicians. No campaign billboards, no television panels, just quiet authority behind a bench. That anonymity is usually a gift. I parked beneath a flickering light, stepped out of my car, and stretched my back. The air smelled faintly of diesel and pine. I checked my phone. 2 unread emails from my clerk, nothing urgent, and walked toward the building. That's when I heard the cruiser. Slow, purposeful, tires rolling over gravel instead of smooth pavement. I didn't turn immediately. I've learned not to appear reactive. The vehicle stopped behind my car. A door opened, then another. "Sir?" I stopped walking and turned. 2 officers, County Sheriff's Department, late 20s, maybe early 30s, hands resting near their belts in that posture meant to signal control. "Yes," I said. "Is this your vehicle?" "It is." "Mind telling us where you're coming from?" "From the city. I'm headed home." The taller one circled slightly, scanning my car with a flashlight, even though the lot was illuminated. "You look nervous," he said. I wasn't. "I'm just stopping to use the restroom." The shorter officer stepped closer. "We've had reports of narcotics moving through this corridor." "I see. Mind if we take a look inside the vehicle?" There it was. Casual, almost friendly. The kind of request framed as cooperation but weighted with implication. "I do mind," I said calmly, "unless you have probable cause." The air shifted. The taller officer's jaw tightened. "You a lawyer or something?" "I'm familiar with the law." He shined the light directly at my face now. "You refusing a lawful order?" "You haven't issued one." The shorter one leaned in slightly. "Step away from the vehicle." "On what basis?" "For our safety." I'm standing still with my hands visible. They exchanged a look. A silent agreement formed. "Turn around," the taller one said. "Am I being detained?" "Yes." "For what specific charge?" "Obstruction." I exhaled slowly. "I have not obstructed anything." "Turn around." The handcuffs clicked around my wrists before I could respond further. Metal is colder than people think. They walked me toward the cruiser. A truck driver nearby watched without expression. A woman exiting the restroom hesitated, then looked away. "Search the vehicle," the taller officer said. "I do not consent," I stated. "We don't need it." They opened doors, rifled through briefcase, garment bag, glove compartment. My judicial robe, folded neatly for the next morning's docket, was pulled halfway from its case and dropped back in carelessly. "Nothing," the shorter one muttered. The taller officer slammed the trunk shut. "You're going to spend the night figuring out how to cooperate better." "I would advise against that," I said evenly. He leaned closer. "You don't get to advise me." They placed me in the back seat. The ride to the county holding facility was quiet except for radio chatter. I watched highway lights blur past through the partition glass. At booking, I provided my name. The clerk looked up, paused, looked again, then back at the screen. She didn't say anything, but her posture changed. The officers didn't notice. They processed me anyway. Fingerprints, photograph, personal property bagged. I was placed in a holding cell for 4 hours before a supervising lieutenant arrived, pale and suddenly very formal. "Judge Whitaker," he said carefully, "there appears to have been an misunderstanding." I met his eyes. "Yes," I replied, "there has." I was released just before dawn. No apology from the arresting officers, just paperwork voided with quiet urgency. When I stepped outside, the sky was pink over the parking lot. I drove home in silence. At 8:30 a.m., my clerk called. "Judge, 2 deputies from Cedar Grove are scheduled for an internal conduct hearing tomorrow morning. Allegations of unlawful search and racial profiling." I paused. "Who is presiding?" I asked. There was a small, stunned silence on the other end. "You are." If you enjoy the video, please subscribe. I slept 3 hours before returning to the courthouse. I did not call anyone. I did not recuse myself immediately. I reviewed procedure first. Judicial conduct rules are clear. A judge must avoid presiding over matters where impartiality could reasonably be questioned. But this was not a criminal trial. It was a preliminary departmental hearing overseen by the County Review Board, held in my courtroom due to scheduling logistics. I disclosed the prior night's incident to the administrative judge by 9 a.m. He listened. "Do you believe you can remain impartial?" "Yes." A pause. "They don't know, do they?" "No." He exhaled quietly. "Proceed. By the book." That's what I intended. The next morning, the courtroom filled slowly. The two deputies sat at the defense table in full uniform. They looked irritated, not worried. Their union representative whispered something that made the taller one smirk. They had not been informed who would preside. The internal affairs investigator stood ready with a file thick enough to matter. I entered from chambers at precisely 9 a.m. The bailiff announced, "All rise." They stood. The taller deputy looked up first. Recognition is an interesting thing. It doesn't arrive gradually. It detonates. His expression drained in less than a second. The shorter deputy followed his gaze. His hands stiffened at his sides. I took my seat. "Be seated." Chairs moved. Fabric shifted. Silence deepened. I looked at the docket. "Deputies Harris and Collins," I said evenly. Neither spoke. "You are present regarding allegations of unlawful detention, improper search procedure, and conduct unbecoming an officer." My voice did not change. "This proceeding will address whether departmental policy was violated. It is not a criminal trial." The investigator began presenting evidence: dashcam footage, bodycam timestamps, audio transcripts. The video from the rest stop played on the overhead monitor. There I was, standing still, calm, hands visible. Their language, their escalation, the absence of probable cause. The courtroom air felt thinner. "Deputy Harris," I said when the footage concluded, "at what point did you establish probable cause for the search?" He swallowed. "We believed the subject was acting suspiciously." Defined suspicious. He refused consent. Refusal of consent is not probable cause. Silence. "Were you aware of that distinction?" "Yes, Your Honor." "And yet you proceeded." No answer. The investigator introduced booking logs, time discrepancies, the 4-hour hold without formal charge entry. Procedural failures stacked like careful bricks. The shorter deputy attempted defense. "We didn't know who he was." "That," I replied calmly, "is precisely the point." No raised voice, no anger, just record. By the end of the hearing, the facts were not ambiguous. Unlawful detention, improper search, violation of constitutional standards. The union representative requested leniency. I reviewed policy guidelines. Suspension pending termination review. Mandatory retraining on constitutional law. Referral to the district attorney for civil rights evaluation. My ruling was methodical, not personal. When I concluded, I looked them directly. The authority granted to you exists to protect the public, not to test its limits. The gavel struck once. The sound echoed longer than it should have. News travels quickly when irony is involved. By afternoon, local outlets had the headline. Community response was immediate, not explosive, but attentive. The sheriff's office released a formal statement announcing suspension pending full review. The district attorney confirmed an independent evaluation. Civil rights groups requested documentation. The rest stop footage circulated internally first, then publicly. There was no outrage in my response. That disappointed some people. They expected fury. They received paperwork. Within weeks, the department finalized termination proceedings. Policy reforms were introduced. Mandatory supervisory approval for vehicle searches absent probable cause. Expanded bias training. Revised detention logging requirements. A civil settlement was offered. I declined personal damages. I requested funds be directed toward community legal education programs instead. Neighbors began greeting me differently in town, not with sympathy, with recognition. The truck driver from that night submitted a witness statement voluntarily. The booking clerk wrote a quiet letter of apology. I responded courteously. 1 month later, I returned to the Cedar Grove rest stop on my way back from another circuit. Same flickering light, same hum from the vending machine. I stepped out of my car, stretched, and walked toward the building. No cruiser followed. No doors opened. Just the sound of wind moving through pine trees. Authority is strongest when it doesn't need to announce itself. I used the restroom, washed my hands, and walked back into the night. Justice, when done properly, is quiet, and it does not require recognition to be complete.